Ready? Start. By consent of the parties, the revision application is heard finally. Para. The accused takes exception to the judgment and order of conviction of the learned Chief Judicial Magistrate Ahmednagar in regular criminal case number 153 of 1996 dated 98 1997 for the offence punishable under section 409 of the Indian Penal Code, in short IPC, and confirmed by the learned additional session judge Ahmednagar by its judgment and order dated 10/8/2004 in appeal number 62 of 1997. Para. The accused was a tenancy Awal Karkun in the Tahsil office Nevasa in 1991. There was heavy rainfall in that area, hence the government had declared compensation for the rain affected people. The compensation was to be disbursed at the war level. Therefore, the collector Ahmednagar assigned the duties to the Talatis, Awal Karkuns and other staff. The accused was one of them discharging his official duty and arranging to pay compensation to the affected persons. Para. The allegation against the accused described that he was to direct an accountant to pay the money to the respective talatis and get the account from the talatis about the compensation money paid and not dispersed to the beneficiaries. The unpaid money was to be returned to him. The talatis returned the balance amount to him. However, instead of depositing the amount of rupees 7,065 with the treasury, he misappropriated the amount and committed the offence punishable under section 409 of the Indian Penal Code. Para. When the misappropriation of the compensation money was discovered, the collector Ahmednagar wide its better dated 3/5/1995 directed the Tahsil to prosecute the accused. Accordingly, the first information report was registered against the accused. He was charged, tried, and convicted. Para. Against two consecutive judgment and conviction, he has raised various legal grounds not considered by the learned trial court and the subordinate appellate court. Para. The learned counsel for the accused has vehemently argued that there was no sanction to prosecute the accused under section 197 of the Code of Criminal Procedure 1977. In short, Criminal Procedure Code. Therefore, the entire trial visit he also argued that most of the witnesses are talatis who have been examined were not inquired into by the investigating officer and their statements were not recorded under section 161 of the CRPC. Both the learned courts had committed a grave error of law in relying upon the statements of the witnesses recorded before the accounts officer who had conducted the departmental inquiry. Similarly, the statement of the accounts officer PW number 26 Damodar Maruti Adsule was also not recorded under section 161 of the CRPC. Therefore, the accused did not have information and material about these witnesses in the form of their statements. Therefore, their statements are nothing but a piece of paper on record. He has also argued that accused was to direct the account to pay the money to the talati for disbursement. Therefore, the unpaid money was to be deposited with the accountant and the accountant was to take the entries in the account book in a few cases. The unpaid compensation amount returned to him by the Talatis was again disbursed to the beneficiaries as they were unavailable when the Talatis went to pay them compensation. He raised a question that the papers of the departmental inquiry cannot be evidence in the trial lodged under the Code of Criminal Procedure. Para. It is prerogative of the investigation officer to make an inquiry from the witnesses acquainted with the facts of the crime, and if he feels appropriate he reduces their statements in writing under section 161 of the CRPC. He would also argue that the law is well established that the accused must be informed in advance of what is the material against him and what he has to face in the trial. Since the statements of most of the witnesses were not recorded under section 161 of the CRPC by the investigation officer, the right of the accused to know the statements against him has been taken away. This is a material illegality of this trial. Both courts have totally ignored these important aspects. Stop.